Did you fully prepare so that if you needed to go to trial, say tomorrow, you'd be ready to go?
There's a few things I need to gather.
Okay. You need to gather for your defense?
Correct.
Did you provide that to Mr. Mulkey or Ms. Guzzi?
It will be provided.
Okay. How are you gonna, you're in jail now, so how are you gonna get your hands on these items?
My mother is already in contact with people who have them.
All right. Did you put your mother in contact with Mr. Mulkey?
I have provided him with her number, and then I will speak with her later today.
Okay. I don't want to get into the nature of what these things are, since that's the subject of your defense, but you indicated that whoever has these items is going to provide them to your mother, who will then provide them to you?
Correct.
Okay.
And they will be presented to the court.
Well, you mean presented to Mr. Mulkey for part of your defense?
Correct.
All right, you came back from North Coast in about mid-April, third week of April, somewhere in there. Is that right?
Correct.
All right. And you were here April 28th for a competency hearing. Do you recall that?
I recall that.
And the report indicated you were competent to stand trial. Everybody agreed, and so I made a finding you were competent to stand trial, right?
That is true.
Okay. So when you were, how long were you at North Coast?
I was there for a period of almost 6 months.
All right. And what happened when you were at North Coast? What'd you do?
While I was there, there was a hearing held. They prescribed medication, a prescription drug called risperidol.
Uh-huh.
I'm not sure exactly what it was for. They said it was a psychologic. During which time they had administered that medication through a pharmacy window next to the cafeteria.
The hearing opens with what looks like a routine plea discussion, but the direction changes almost immediately when the defendant refuses to change his plea. That decision shifts the courtroom from negotiation mode into trial preparation mode.
After it came in a bottle, they would open the bottle in front of me. I tasted it. It tasted like medication. It had a strong taste to it. The second time I would go back to the window at the end of the day, it would taste different. And over the course of the time that I was there, each time the same thing seemed to happen. So it would have a strong taste as soon as they opened the bottle, and then each time after that, it would either change flavor or it would have a
Are you talking about a pill?
less of a flavor to it.
A pill?
It was a liquid medication.
Okay. So they would administer you this liquid, you would drink it, and then...
It was like 4 milliliters,
Okay.
a 4 milliliter dose morning and evening.
At some point, did you stop taking that?
Immediately.
Okay.
I would go to my room and wash my mouth out in my sink.
All right, then and you guys can help me out if I'm recollecting wrong, but was there a point where we had a hearing to determine whether medication should be administered to you against your will?
There was a hearing. I did not agree with the findings of the hearing.
Right. But there, Mr. DeFeo.
Therefore, I took the medication.
Okay.
I just took it to my room and washed my mouth out in the sink.
So did we have a forced med hearing?
Yes,
Okay.
Your Honor, if I may, my records indicate that on or about December 2nd of 2025, we had a hearing right around that time, Your Honor.
Okay. So after that hearing, that medication was administered to you.
It was prescribed and administered almost immediately.
Right. And then over the course of the next few months, then the determination was made that you were competent to stand trial.
That is correct.
When you, have you been taking medication since then?
I have not taken any.
Are you prescribed medication currently?
There's medication available.
All right. And you're not taking it?
That is correct,
Why not?
because I did not feel it is needed.
Okay.
And I've had problems with medication in the past where it has altered my thought process. And the previous 2 cases that I've been here, I've seemed to find that same problem happening right there at the pharmacy window. Both at North Coast originally when I went there the first time,
Okay.
as well as Twin Valley while I was, would have been the last case that I was in front of you for.
Okay. So you don't see any, you don't see any benefit to the medication they prescribe to you?
I do not. I see it as a detriment.
Okay. When you had that back at the end of last year, beginning of this year, when that medication was then ordered and they gave it to you, do you think that helped your thought process at all?
It helped clear up a few things as far as what was taking place around me to cause the problem.
Okay. And then obviously that medication wears off after a period of time.
As does most.
Right. Well, my concerted guess is that if you took your psych meds on a daily basis, that you would maintain a certain level of your thought process. If you stop taking it, that's going to change it, right?
It may or may not. It may have helped fix the problem by understanding what the problem was in the first place.
Okay. So do you think you have a better grasp of things now than when that medication was administered to you and it was in effect?
I have a crystal clear picture of what was taking place.
Okay. All right. All right, have a seat, Mr. Young. Let me see counsel in here.
Once the discussion turns to evidence, the judge's focus becomes practical rather than legal. The defendant claims additional material still needs to be gathered even though he is already in jail. That immediately creates a logistical challenge instead of a legal one.
24-1481, Travis Fain, violation of community control. Final hearing. Violation on March 17, you were indicted in Cuyahoga County. Aggravated trafficking of drugs, felony 3. Aggravated possession, felony 3. Trafficking of cocaine, felony 4. Possession of cocaine, felony 4. Trafficking of fentanyl-related compound, felony 4. Possession of a fentanyl-related compound, and possessing criminal tools. You understand that charge?
Yes, sir.
Tested positive for marijuana April 16th. You understand that charge?
Yes, sir.
We never concluded the first violation, Jamie?
No, Your Honor.
So we're here for a final hearing on that previous violation, which was driving without a license. You understand that charge?
Yes, sir.
Ms. Novotny?
Your Honor, at this time, Mr. Fain would like to waive the final hearing and admit to the violations.
Is that what you want to do?
Yes, sir.
What's your plea to the violations?
Guilty.
I'll accept your guilty plea and find you guilty, Ms. Novotny.
Your Honor, with regard to the violations, I know we originally were violated for ultimately driving under suspension, and we did continue it out to see if Mr. Fain can get his license back. Ultimately, around that time, he was working part-time at McGregor Nursing Home, and unfortunately, he was laid off and experiencing a lot of financial hardship. Additionally, Your Honor, with that respect, he's been suffering a lot of medical issues, specifically back issues and his stomach issues. He was going to physical therapy through Metro Health every 2 weeks, from my understanding, and going to counseling with Metro Health, as well as any medication compliance. One thing that he was able to achieve, Your Honor, is that he was able to receive an insurance card with Founders that it doesn't expire until September of 2026. I know due to the financial issues and ultimately the medical issues that he's been experiencing, he was trying to achieve on applying for Social Security due to that. So he's on a fixed income. That was the majority of his issues, why he couldn't get his license back. And we're sitting in front of you today. Ultimately, Your Honor, we're just asking for any type of leniency and to place him on community control. Thank you.
Mr. Fain, what do you want to tell me?
I apologize. I was stressed out, high anxiety from them being indicted on that case. I thought they was charging the guy in the back seat with those drugs. And I got an indictment 9 months later, and I wanted to try to fight the case.
You were pulled over on August 11th, charged with no operator's license.
All right, they didn't put no drug charges on that ticket.
Pled guilty September 17th. Did you tell Ms. Crook that there were also drugs involved and drugs in the car?
No, I did not,
Why not?
because they was charging the guy in the back seat,
Okay.
from my understanding.
And what steps did you take to get your license?
I was like my brother said, he was gonna help me out with the get my license, but this happened so fast, it just spent out of control. So now
Well, the violation was August 11th. The indictment was March 17th.
I don't know. I mean, I don't have no job and then I've been going to physical therapy and my program, so it's just been tight, real tight.
All right.
So I had asked my brother. He said he was gonna pay it off. I just had to get a whole, full, complete number. But you said I had to have it by July.
The conversation then moves into a completely different area by revisiting the defendant's competency history. This is no longer about guilt or innocence. It is about whether the legal system already addressed questions surrounding his ability to participate in trial.
All this happened.
You were placed on probation June 11th of 2025.
Yeah, I complied with all the rules for a year and a half.
Well, I know you didn't.
For a year.
You picked up this NOL in August. You've been on probation for 11 months now. So 2 months into it, you picked up this no operator's license. Now you picked up this drug trafficking charge. I don't know how that's going to come out. It doesn't really matter. But somebody had drugs in that car that you were in, and then you test positive for drugs. Now, when I look back at your pre-sentence report, you've got a possession of cocaine, a felony 4, in 95 that you went to prison for about 11 months. Got out in 97, pick up a trafficking of cocaine in 2000, trafficking of marijuana in 2000, you went to prison for about 6 months. You get out in February of 01. October of 01, you get a felonious assault with a firearm specification, you go to prison for a little under 6 years. Get out in August of 07. 09, you pick up a weapons charge and a drug trafficking charge. Go to prison for about 9 months, get out in May of 10. 14, you get a domestic violence misdemeanor. 20, Cuyahoga, you get a F3 drug possession. F4 trafficking. placed on probation. 22, attempted drug possession. And then in 24, December 24, you get this aggravated possession of drugs. So, and I put you on probation with that past record, and you haven't done what you're supposed to do. So you continue to engage in the same activity, and I gave you simple conditions. No drugs or alcohol, get a license. And to continue the treatment you were in, you haven't done it. So I'm going to find you're no longer amenable to community control. And after consideration of all the statutory factors, I'm going to sentence you to 7 months in prison with credit for 24 days, and the costs are assessed. Anything else, Ms. Novotny?
No, Your Honor.
All right, we're adjourned.
All rise.
The judge now broadens the discussion beyond the current violations and examines the defendant's overall performance on supervision. A probation sentence represents judicial trust, and the court measures whether that trust produced meaningful change. Instead of focusing on isolated mistakes, the judge highlights how quickly violations appeared after probation began. The sentencing analysis becomes increasingly difficult for the defense once the judge reviews decades of criminal history. Rather than treating the new charges as isolated events, the court places them inside a much longer pattern stretching across multiple convictions, repeated prison terms, and recurring drug-related offenses. This historical review serves a larger purpose than criticizing past conduct. It helps determine whether previous punishments successfully changed future behavior. Every return to similar criminal activity weakens the argument that another period of community supervision would achieve a different result. Sentencing decisions frequently depend less on one new allegation than on demonstrated patterns over many years. The judge builds that conclusion methodically, showing why the current violations cannot be evaluated independently from the defendant's broader criminal record. The hearing ends with the judge reaching the central legal conclusion that ultimately controls the outcome. The court determines the defendant is no longer suitable for community control because repeated opportunities failed to produce sustained compliance. Notice that the final decision is not driven by anger or frustration. It rests on accumulated evidence showing that basic probation conditions were not satisfied despite multiple chances. The sentence reflects a shift in judicial philosophy from rehabilitation toward accountability after confidence in supervision has been exhausted. By the time prison is imposed, the discussion is no longer about isolated excuses, pending charges, or future promises. It becomes a judgment about risk, reliability, and whether the court can reasonably expect different behavior if another opportunity is granted.